Okay, this is Wilson versus Auto Owners Insurance Company and Homeowners Insurance Company, docket number 16-913NF. And this is the time set for hearing on two motions. We have the plaintiff's motion to quash the defendant's non-party discovery subpoenas, and then the plaintiff's motion to file a motion for partial summary disposition. And I guess I'll first take appearances for the record.
Yes, Stephen Sinus on behalf of Plaintiff Myron Wilson, and he can also introduce himself, but my colleague John Homa is here alongside with me for purposes of this hearing.
I'll confirm that I am here.
Steve Byrne on behalf of the defendants.
Okay, thank you. You want to go ahead with your motion to quash, Mr. Sinus?
Yeah, would the court like me to start with that one? I can address both at the same time. However, the court would like me to.
Both at the same time would be great.
Okay, I think that there is some relationship to some extent.
Yeah.
So, yeah, let me just start. I tried to, or we tried to, in our motions, give the court a summary of all that's gone on in this case, and perhaps the court remembers the various rulings it's entered. It began with a case involving an entitlement issue to no-fault benefits. The court ruled that he was entitled to benefits. Defendants have not challenged that. There's other rulings on attendant care. Attendant care claims have been settled. As this court is aware, this case has been pending on its docket for the last 4 years. And what we're left is with a number of medical expenses. The most of which this court has ruled as a matter of law are reasonably necessary for our client's care, recovery, and rehabilitation for purposes of the Michigan No Fault Act. And what we're really left with is the issue of whether the medical expenses satisfy the reasonable charge standard. And Auto Owners has made it very clear in this case that despite this court's previous order that Auto Owners is responsible for the reasonable charge under the MCL 500.3171A, Auto Owners has maintained that it only has to pay the amounts paid by Medicaid, despite this court saying that is not the law. It's not consistent with the appellate court case law. They even pursued an interlocutory appeal on that issue, which was denied, and they've come back and they've maintained throughout this entire process that they believe that they're still right on that issue. What happened this spring was their request to get discovery from us and our request to get discovery from them about the reasonable charge issue to whatever extent it mattered in the litigation. And we went ahead and produced an affidavit from our medical billing expert. We produced that medical billing expert for a deposition. And along the way, we asked Auto Owners for their information on reasonable charge. And this stems back to a discovery request we sent back in 2017. And to this day, Your Honor, they've given us nothing in the way of proofs or any documents they will rely upon in contesting whether the proofs we put forth on the reasonable charge issue are actually satisfy the reasonable charge issue. So we're here today to talk about their attempt to get additional discovery on reasonable charge at the final hour, with still being the case that they've never produced discovery about what they're going to be relying upon. So getting to the specific issues before the court, this motion to quash this subpoena, I just want to say some background information about this subpoena. It was served in the first week in November. I think I got it. I think it's dated November 5th. I may have gotten the same day or the next day after. There was no reach out to us about this coming. There's been no calls or any other communication with defense counsel about the subpoena. And it took us filing this motion to quash it for them to even reach out to anybody. And they tried to reach out in the final hour to Marquette General Hospital's legal counsel, who intervened on their behalf regarding the subpoena. And this has all been transpiring over the last 24 hours. And our basic point is it's too late in the game to be doing this. The case evaluation hearing is December 10th. So if there's ever a simple reason to deny a subpoena on discovery, it's when it's being asked to be responded to within 3 days of the case evaluation hearing. To whatever extent their response indicates that there were emails sent about this deposition they want to take of this person named Kathy Haglund, the emails say what they say. All I can say to this court is that after that June 30th email, There was never any further inquiry about lining up the deposition of Kathy Haglund. The defendants went forward and wanted to depose our billing expert. We made that happen for them. And there's been no other reference to wanting to depose her. We even went to facilitation in September, and that went nowhere. And there's been no reference to wanting to depose her since then. It was the subpoena out of nowhere asking for all this information that's being sent out at the final hour here. And we just think that after 4 years of litigation, we shouldn't have to be dealing with a deposition 3 days before a case evaluation. And then with regard to our filing of the motion for partial summary disposition after the deadline, defendant's response indicates that we're kind of contradicting ourselves by asking you to quash their discovery subpoena, but give us, additional time on something there was a deadline on. Your Honor, the reason why we're filing this motion for summary disposition and asking this court to hear it is because we now have gotten to the point where they still haven't produced any information on the reasonable charge. We produce all this information, and I'm not trying to get in the merits of whether we'd win the motion, but the point of filing at this point in the game is to bring to the court's attention that this may be ripe for summary disposition, that it may be a matter of judicial economy and just practical handling of this case for this court to hear this motion before we have a trial on reasonable charge that has been countered with no evidence or other proof. So that would be my overall big picture response to both matters. I'd be happy to take any questions the court may have, or let Mr. Byrne respond here.
If it's too close to case eval, can't you adjourn case eval?
We can, but Your Honor, they want to take this case all the way up the appellate ladder. They've been saying that. We're here. We want case evaluation to occur. They've had Kathy Haglund's affidavit since 2018, and the reality of getting this deposition in and the way they've tried to get it in here, it just should not be allowed. It's something that is causing this case to be, further on this court's docket, and it's really just going against the spirit of what the litigation process should be about.
All right, thank you. Mr. Byrne?
Once again, Your Honor, Stephen Byrne on behalf of the defendants. Your Honor, first I'd like to apologize for my attire. I had no idea I was covering this today, and I don't have a proper suit on, so I apologize for that. Beyond that, this reminds me of when I was practicing in Kent County, Judge Redford, I probably heard him say, "What's good for the goose is good for the gander," about a dozen times. And it seems to me like a perfect example of that. We're asking for these depositions. We reached out to plaintiff to schedule these. They never gave us dates. We did what we could with case evaluation coming up, and we issued these subpoenas. Now they're asking you to quash those, but grant their a motion for leave to file an SD motion 2 years after the deadline. It seems to me that what's good for the goose is good for the gander. Either we both get to do these things 2 years after the deadline, or neither of us get to. I'm of the opinion that the court should allow us to conduct these depositions and allow plaintiff to file his motion for summary disposition. If the court is inclined to deny them both, then that's the prerogative of the court. But I would say it would be unfair to say yes to one and no to the other. With regards to a case evaluation, if the court wanted to adjourn case evaluation, that's up to the court. But I think that in light of the fact that we were told that they would get us dates back in May or June and never did for these depositions, I think that indicates that they were okay, at least at that time, with doing these depositions. And there's no reason not to go forward with them. Furthermore, in light of the fact that trials are not going to be taking place anytime soon, neither one of these occurrences, whether it's depositions or this motion, are going to affect the court's timeline in terms of a trial, I suspect, in any way whatsoever. So I would submit, Your Honor, that you should deny their motion to quash and grant their motion for leave to file the SD motion.
All right. Did you have any last words, Mr. Sinus?
Yeah, I just want to clarify, the SD deadline, as far as I understand, is not 2 years overdue. It ran in September. And so we were waiting for their discovery responses on the reasonable charge issue, which is still to this day never come. And so allowing them to continue on this discovery is just, as I said, it goes against the spirit of litigation. I just want to say I have no bad rapport with fellow defense counsel. Mr. Nelson is the primary attorney. He and I handle cases well together all the time. I just think this is a unique set of circumstances where this case, which has been perpetuated by auto owners, thumbing its nose at the rulings of this court, believing that it can continue on this process, allowing this to go forward this final hour is just an extension of that. And it's just unfortunate in this unique circumstances of this case. And so the SD that we asked to file is something that could have been filed in September. We waited, they haven't responded. Now they want more time to pursue more discovery. And I'm just not sure where this is all headed.
Okay, I don't want this to break down into an argument, but in your motion, you say the deadline for filing motions for summary disposition in this case was August 8th, 2018. Was it?
I'm sorry if that, to be honest with you, I'm not, I was not the one who put that in the brief. I believe that the scheduling order says September, the most modified version that sets forth the date of this case evaluation. And if the court can give me a minute, I can give you the date of the order.
That's okay. I just feel that, I always err on the side of granting requests to file motions for summary disposition past the deadline, because I just think it promotes efficiency and justice and everything that we're supposed to be about. So I don't have a problem allowing a late filing of a motion for summary disposition, whether it's a couple months or whether it's a couple years. If it's called for and we're in a holding pattern anyway, why not? But I am also going to deny the motion to quash the subpoenas. The defendant has said they're no longer seeking the document production, just the testimony. And although the plaintiff complains that it's too far into this matter, that is sort of ironic, seeing that the plaintiff wants to file a motion for summary disposition. The plaintiff also says it's too close to case eval, but they don't really say why that's a problem. If it is, I'll sign any order you need me to sign if you want to stipulate to postponing case eval or whatever you need me to do. And then they complain that the subpoenas are burdensome. But again, the defendant's already, I think, relieved a great deal of the burden by saying it's just testimony, not, I don't mean just testimony, but that it's testimony and not a vast amount of document production. So I'm granting the motion to file the summary disposition and denying the motion to quash the subpoenas.
Thank you, Your Honor. As far as this issue of the case evaluation, I just have a question. Can we understand the court to be inclined to adjourn the case evaluation if we believe that if the parties agree that that's what they want to do, or would we have to decide that here and now? Are you saying that the case evaluation, it should go ahead on December 10th?
No, I'm saying that if you don't want it to, it doesn't have to.
Okay.
I don't hear that either one of you are strongly opposed to adjourning it. I mean, I think you were a little more before you motioned, Mr. Sinus, but given what we have now, if you both want to adjourn it, just adjourn it, if that makes more sense.
Okay.
Did you want to have it before the summary disposition motion? Was that what you were wanting?
No, it has to do with just dealing with,
Okay.
whatever happens at a deposition 3 days before a hearing, and that we've already going to have to send our summary in for, so it's just a convoluted way of conducting the process, but, we can deal with that.
I mean, if the court wants to rule on the summary, or on the case evaluation issue right now, I mean, it seems like plaintiff is inclined to move it. I have no opinion. If the court wants to render a decision so that we don't end up in some sort of tit for tat, after we get out of the hearing here,
Okay.
I'm okay with that.
All right, fair enough. Then in light of the motions that I just heard and the ruling that I just made, I think it's prudent to adjourn the case eval you can ask for a new date from the case processing coordinator.
Okay. Thank you very much.
Thank you, Your Honor.
Thank you, Your Honor.